Major breaking news out of state court in Oregon. An Oregon trial judge has declared that ballot measure 114 is unconstitutional under the Oregon State Constitution, specifically under Oregon State's right to keep and bear arms. A major win for gun owners in the state of Oregon. Huge news, and I don't think it's going to be that easy for the Oregon Supreme Court to try to overturn this. I'm not even sure they're going to try. We will see soon enough, but again, big win here on the eve of Thanksgiving 2023. Let's talk about it when we get back. Hey folks, it's Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, big win today, big win. Oregon Judicial Department trial court in Harney County Circuit Court. A judge there has declared that ballot measure 114, which is the statewide referendum against basically gun owners, is unconstitutional on its face. That includes both major parts of the law, specifically the so-called large capacity magazine ban has been deemed facially unconstitutional under the Oregon State Constitution. Now, this is key. This decision we're going to talk about in this video does not relate, I repeat, does not relate or concern the federal constitutional right to keep and bear arms. That means it does not relate to the Second Amendment's right to keep and bear arms. This decision from the Judge Ruscio, I believe. I hope I don't screw that pronunciation up. I probably did. But Robert Ruscio has declared that under the Oregon State Constitution, the right to keep and bear arms, both the ballot measure 114 dealing with large capacity magazine bans is unconstitutional, as is ballot measure 114 to the extent it deals with the so-called permit to purchase scheme. That also is facially unconstitutional. We're going to start with the major thing involving the quote-unquote large capacity magazine bans. These are magazines that hold more than 10 rounds. Bottom line, of course, is that the judge correctly concluded right off the top, as we've talked about, that a magazine is a necessary component of a firearm under Oregon law. He points out that the definition of a firearm under Oregon law includes a weapon by whatever name known, which is designed to expel a projectile by the action of powder. The projectile and the powder are contained within the magazine in the form of ammunition, of course. So obviously, you can't have a handgun, a modern-day handgun, or modern-day rifle without some form of a magazine. Of course, what I don't see in this opinion, and the judge could have thrown this in here, a magazine that bans a magazine ban of, you ban magazines that hold more than 10 rounds, you are effectively banning a type of firearm, i.e. Firearms that can hold more than 10 rounds and can fire more than 10 rounds without having to reload. So in addition to the fact a magazine ban is a magazine ban because a magazine part of an arm, and thus that's unconstitutional on that level. It's also unconstitutional on the level that you're banning a commonly owned firearm. So with that said, the judge did a great job here. He then goes on to lay out in extreme detail that the way to interpret the Oregon Constitution, and this is a critical nuance I want you to understand. Remember I told you this case does not involve the Second Amendment right to keep and bear arms under federal law. It only deals with the Oregon State Constitution. And for that matter, let me read the text of the Oregon State Constitution to you. The state constitution of Oregon provides, quote, "The people shall have the right to bear arms for the defense of themselves and the state, but the military shall be kept in strict subordination to the civilian power." That is Oregon Constitution, Article 1, Section 27. Again, that provides the people shall have the right to bear arms for the defense of themselves and the state. That is the text of the Oregon right to keep and bear arms. Now, remember I told you this is different than the federal Constitution. The reason why that's important is the federal Constitution is interpreted by text first, burden shifts to the government, and the government has to come forth with historical analog laws at the time of the founding, 1791, to define and describe any limits, if there are any, to the Second Amendment. Now, when you're dealing with the Oregon State Constitution, you're dealing with Oregon constitutional law. Okay? Now, as a consequence of that, the judge here talks about the five-part test. The five-part test that the Oregon Supreme Court has previously said has to be considered in whether or not a modern-day gun control law violates the Oregon State Constitution. Now, that five-part test laid out in this opinion, which I'll link to down below, is first, the Oregon Constitution prevents the legislature from infringing on the citizen's right to bear arms in self-defense. Second, the term arms includes firearms and certain hand-carried weapons used for self-defense at the founding of Oregon. Third, the legislative intent, or I should say the legislative restraint, is valid and reasonable if it is addressing dangerous practices which allows for regulating the carrying or use of firearms. And fourth, restrictions must be reasonable in scope and for the purpose of promoting public safety. And fifth, the reasonable restrictions cannot unduly frustrate the right to bear arms. Now, I hate a 5-part test. We don't need to get into the details here, but whenever you see a multi-part test, it's terrible as a general matter for the Second Amendment and for the right to keep and bear arms, because you're basically giving permission for judges to balance away the interest of public policy, the powers, interest, and authority of the government against private rights to keep and bear arms. So while this is the law of Oregon, I can't control that. It's the Oregon State Constitution. The Oregon Supreme Court over the last many decades has set this out. But as a general matter, we don't like multi-part tests. We can talk about this in a separate video. But again, this is not the standard for the Second Amendment. It's for the Oregon State Constitution. The good news is, in this case, the case is so overwhelmingly in favor of the right to keep and bear arms that the judge here said that this law, Ballot Measure 114, simply cannot stand under the Oregon State Constitution, regardless of what the federal Constitution says. And again, the first thing he points out is that these magazine bans are clearly unconstitutional because the right to bear arms presupposes the right to, firearms that actually work. Then he goes on, of course, to talk about various things, such as he explains that in 1857, when the Oregon State Constitution was being discussed, specifically he writes that the statutes support the functional reality through the codification of the above definitions. Without a magazine, the remaining components of the gun is not a firearm. He then goes on to talk about how the conservative pioneers who voted for the Oregon Constitution in 1857 wanted the best shotguns, rifles, handguns, including revolvers and pepper boxes, and muskets that they could afford. The judge goes on to say there was a deep desire to have repeating features. Arms consisted of those weapons used by settlers for both personal and military defense, excepting cannons and other heavy ordnance. He goes on to say that the constitutional delegates and voters of 1857 Oregon would be impressed by the advancement of today's firearms technology, but they would understand our current stock of firearms as direct descendants of those they possessed, including multi-shot and repeater technology. So basically what he's saying is, if you look at the time of the creation of the Oregon Constitution, they would have understood that modern firearms are descendants of that firearms technology and thus would be protected. Then the judge goes on and says that the court finds that large capacity magazine bans do not enhance public safety to a degree necessary to burden the right to bear arms. He talks about how he heard testimony from several sheriffs from Union County and from Harney County that testified that for their own protection and that of their deputies, they issued quote-unquote large capacity magazines. They talk about how they carry Smith & Wesson 9mm firearms with a magazine capacity of 17 plus 1, presumably one in the chamber. These sheriffs testified at trial in front of, there in Harney County, Oregon. There's 17 rounds in the detachable magazine and 1 round in the fixed magazine. Additionally, they are issued 2 additional 17-round magazines. One of the sheriffs, Sheriff Jenkins, provides law enforcement protection for 10,000 square miles with 6 sworn officers, where it can take an hour and a half to respond to an emergency. He issues a Glock Model 22 40 caliber pistols with 15 plus 1 and 2 additional detachable magazines of 15 rounds. He also testified that he issues AR-15s, 223 calibers with 25 to 30 capacity magazines with a couple of 10 rounds plus 1 magazines as well. The court then went on to embrace and quote an amicus brief from the National Police Association, which was filed in this case. The court agrees with the National Police Association amicus curiae brief filed on January 31st, 2023, which reads, quote, because police officers are defending themselves against the same criminals as citizens, their experience is highly relevant to the appropriate scope of self-defense. Over the years, police departments across the nation have abandoned service revolvers in favor of modern semi-automatic weapons with larger magazines. This is true even though police are often working together as a group with even less need for higher capacity magazines than individual citizens attempting to defend themselves. Exactly right. As we've talked about on this channel before, if the police and I are walking the same streets, I need the same firepower that the police carry, and if the police are carrying M4s or AR-15s with 30-round mags in Times Square in New York City, then I should be allowed to carry a handgun with more than 10 rounds in Times Square as well. Because if the police need it for self-defense and they're walking the streets that I'm walking, why shouldn't I have that protection as well? What are they protecting their lives from? And it's obviously the same criminals that I'm trying to protect my life from as well. The court then goes on to point out that the large capacity magazine ban is unduly burdensome. He goes on to write that the court finds that 10-round magazine bans are no panacea to prevent a mass shooter based upon the evidence in this case. A motivated mass shooter could carry well over 100 rounds in 10 separate magazines and readily release a detachable magazine from a firearm and reload in 2 seconds, offering none of the supposed protection promoted in the preamble or voter's guide for ballot measure 114 by banning quote-unquote large capacity magazines. The court then goes on to say that he found no proof, there is simply no proof offered in this case, that demonstrated that large capacity magazine bans would reduce the number of casualties in the future. He said any such conclusion would be mere speculation by the court, and he refused to engage in it. So the bottom line here is that the court, when he balanced out the pros and the cons of magazines and concluded there was really no benefit to banning these magazines that hold more than 10 rounds, and there were obviously self-defense benefits as demonstrated by the fact that all the police officers testified that they carried on duty and off duty. He also points out that it was questionable whether or not an off-duty police officer could carry magazines that hold more than 10 rounds under this law. So as a consequence, the judge concluded that the ballot measure 114 large capacity magazine ban is facially unconstitutional and would be permanently enjoined by virtue of a judgment to be entered on December 8th of this year. Now, we also cannot forget that there's another major part of ballot measure 114 that was declared unconstitutional under the Oregon state constitution specifically. And again, you'll see the opinion down below. The judge said that ballot measure 114 permit to purchase scheme is facially unconstitutional because Oregon citizens have a right to self-defense against an imminent, which means immediate, an imminent threat of harm which is unduly burdened by this ballot measure. The court goes on to say there's 3 salient factors that are allowing him to conclude that this violates the Oregon Constitution. The first is that ballot measure 114 delays the purchase of firearms for a minimum of 30 days. The second thing is the permit to purchase program derives its language source in the concealed handgun license statutes. And the FBI, and this is critically important, and I don't see how the Oregon Supreme Court can get around this problem. He points out that it was agreed to by the parties that the FBI refuses to conduct criminal background checks, and thus because under the law, the FBI is supposed to conduct criminal background checks as part of the state law that was just enacted, and the FBI simply will not do it, and everyone agrees they will not do it. It means how can this possibly stand as a law? This permit to purchase scheme is fatally flawed because, again, it presupposes the FBI will be running background checks, and the FBI says we're not doing it, and everyone agrees that's the case, so there's no dispute of fact over that. So, again, he basically said there's no way this law can stand. He also points out this law cannot be severed because of the way it's drafted. He cannot rewrite the law, nor will he rewrite the law on behalf of the people that proposed this or enacted this or passed this. Then the judge goes on to say that the right under the Oregon Constitution, the right to bear arms under the Oregon Constitution, is also unduly burdened by this 30-day delay because he says the ability to respond to an imminent threat of harm is unduly burdened because, if you have to wait 30 days, you cannot respond to an imminent threat. So obviously he says that is clearly a major restriction and a harm to the right to bear arms. Then he goes on to point out, as part of this analysis, he points out that much of Oregon state is rural, right? It's not urban, it's rural in nature. And he goes on to say that certainly in rural communities, the ballot measure weighs negatively on public safety. He goes on to say the court finds that the testimony of Harney County Sheriff Dan Jenkins, who leads 5 deputies, and Union County Sheriff Cody Bowen, who often leads 15 deputies, demonstrated definitively citizens cannot rely on law enforcement to respond quickly to their needs if they are subject to a break-in or a threat of deadly physical harm. Victims can be left without a law enforcement response for hours. For hours, was the testimony. A citizen's need to protect themselves, their loved ones, and their property is immediate, as there is no one else will be there to do it for them, i.e., you are your own first responder is essentially what the judge is saying in this Oregon case. And we've talked a lot about this, and I urge you all to continue to adopt that rhetoric. You are your own first responder because it's factual, whether it be here in the United States or, as we found out recently, unfortunately, in Israel as well. And the last critical point involves this FBI issue. Specifically, the judge says the lack of a Federal Bureau of Investigation's background checks means that the permits cannot be issued without full judicial review, unduly burdening the right to bear arms. Goes on to say that the parties in this case have stipulated that the FBI will not conduct background checks on applicants who apply for a permit to purchase a firearm. The defendants invite the court to assume that the permits will be issued anyhow, but the defendants provide no evidence as to why that assumption would be true. He goes on to say specifically that a plain reading of the statute, i.e. Ballot Measure 114, contradicts that assumption, which says, quote, the Federal Bureau of Investigation shall return the fingerprint cards used to conduct the criminal background check and may not keep any records of the fingerprints. Upon completion of the criminal background check and determination of whether the permit applicant is qualified or disqualified from the purchasing or otherwise acquiring a firearm, the department shall report the results. But then it goes on to say Ballot Measure 114 further directs that during the FBI background check, certain other things will occur. But again, there is no background checks because, quote, the FBI has stated that language of the permitting agent or the designee prohibits the FBI from assisting Oregon because Public Law 92-544 is clear that only law enforcement can receive the FBI background check, not designees. So basically, the FBI is saying, we're not going to participate in this. And as a result, the judge says, bottom line is this permit to purchase policy is unreasonable and unduly burdensome on the right to bear arms under the Oregon right to keep and bear arms, which is Article 1, Section 27 of the Oregon Constitution. So there you have it. So where this is going now, the judge has asked the parties to submit proposed judgments to him in the next week or so. He intends to enter a final judgment in this case, ruling against the state of Oregon in favor of the plaintiffs, saying that this law will be permanently enjoined in all respects. Ballot Measure 114 will be enjoined in all respects permanently. And then, of course, presumably the next step will be that the state of Oregon will seek an appeal to the Oregon Appellate Court and perhaps directly to the Appellate Supreme Court. We'll see what they do out there. And of course, this is all independent from anything going on in federal court. So it really doesn't matter at this point if federal courts reject or rule against the Oregon State Court, or I should say against the Oregon government in this case, because at this point, the statute is, the ballot measure is enjoined by virtue of the state decision. So regardless of what happens with the Second Amendment, on the good news front, as of now at least, Oregon gun owners seem to have won this completely thanks to this state court judge right here and right now. We'll see if it stands up on appeal. If it does, then it really doesn't matter what happens in federal court. And I know you have some federal judges in Oregon that are, shall we say, doozies, in my opinion. Again, we don't need to get into that right now because it's a happy day right here and right now for Oregon gun owners. And let's hope we have more happy days out there for Oregon gun owners. The Second Amendment, of course, the Oregon constitutional right to keep and bear arms. All right, folks, I hope you learned a little bit something here today, right before Thanksgiving. And again, if you haven't subscribed to the 4 Boxes Diner, please do so. Don't forget to follow me on X at 4 Boxes Diner, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.